Honorable Chief Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention. The court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Well, good morning. The weather being what it is, one of our colleagues is going to be a little bit late, and we're going to begin. Justice Viviano is on the road, and apparently has been on the road for some time, but made limited progress. To the extent that he misses one, possibly two of the arguments, he, of course, will read the transcript, and he will watch the recording, and he will be up to snuff, I'm sure, very quickly. But he apologizes for being late this morning for those largely unavoidable reasons. Also, there's a possibility we may adjust the schedule slightly this morning. If we do, we'll let you know, but for the time being, we're going to go ahead with the schedule as it exists. Let me say one thing before we begin arguments. For the first time in 6 years, the gavel has passed into new hands, as is the tradition of the court, but it will be difficult for any justice to exercise as steady a hand in this courtroom as has Bob Young. While this court will be without his command of the gavel, I suspect that we'll continue to benefit from his command of the discussion at these oral arguments. And the bench of the court, the bench and the bar, and all of those who've been served by the rule of law in this state, I believe, owe him a great deal for his public service on the court for the past 6 years. I also note, or at least I thought I noted, that we had some students from Brighton. Is that correct, or no longer? Okay.
The weather's got them.
Well, I'm sure they'll join us at another point, and we'll look forward to having them here. Let me welcome counsel, without whom little could be accomplished here. As always, there are 30 minutes per side for grants, 15 minutes per side for arguments and application, and in each case there'll be a 5-minute free fire zone that may or may not be waived at their discretion, at counsel's discretion. I'm sorry, 2-minute free fire zone on Moe's, that's correct. Your arguments, I believe, will be optimized if first you accept that each of the justices is familiar with the basic facts in your case, and second, you recognize that the court is committed not only to resolving your case in a manner faithful to the law, but countless numbers of similar cases that may arise throughout Michigan tomorrow and in the years ahead. I call the first case Shae Kevin Graham versus Sharea Foster.
Good morning, Your Honors. Tammy Daniels appearing on behalf of the defendant appellant in this case, Sharea Foster. Your Honor, we are here today because we asked this court to issue a order reversing the lower court's, the portion of the lower court's decision that found that Christopher Foster, my client's husband, who is not a party to this action at this time, although a necessary party, can be added to this case, despite the fact that the statute of limitations has lapsed based on the relation back doctrine. We believe that that is an incorrect reading of the law. It is inconsistent with this court's opinion in Miller v. Chapman, and it is inconsistent with the 30-plus cases that the Court of Appeals has decided consistent with Miller v. Chapman and Michigan Court Rule 2.118D. The Revocation of Paternity Act, as we are all aware, is a relatively new statute that provides a very brief window of opportunity for otherwise excluded alleged biological fathers to create an opportunity to establish standing in order to challenge the paternity of a child born during the pendency of a marriage. In this particular case, this window of opportunity is closed. The paternity of this child has been settled, and we should not at this time reopen that window and give the plaintiff another bite at this apple, another opportunity to disrupt this family, my client, and this child. It is not in the child's best interest nor in the interest of justice. Statute of limitations has lapsed, and we should move on. I have nothing. I'm open for questions.
Thank you.
Could I have sympathy for the policy argument you make, but the statute, arguably, the policy embodied in the statute allows someone external to the marriage to invade the marriage for the purpose of establishing a different father relationship. But it strikes me that the question in this case is whether the line of Court of Appeals cases that suggest that the addition of a necessary party after the statute of limitations can be had without violating the statute of limitations is founded on an odd reading of two older cases of ours, Casserly and Prather. I'm not sure I understand why those cases stand for the proposition that there's an exception to the rule that statute of limitations lapses if you don't bring a necessary party in a timely way. Do you have a construction of those cases that?
So I'm not sure what your question was.
Well, the theory has been, in some Court of Appeals cases, is that there is a potential for relating back when you bring a third party in who is a necessary party, and their reliance on Prather and what's the other case? Casserly. I don't read those cases quite the same way as providing that principle, that exception.
So I read Casserly and Prather. I was challenged by
No, everybody is.
challenged by attempting to interpret them, but I did read them to say that in cases where the existing defendant's rights were not affected, that a person could be brought in after the statute of limitations. I also interpreted it having a slight tolling. The statute in question, what was it? 3 compiled laws, 10718, specifically says that if you file the complaint in time, that someone could be added after the fact. I think it's 10719. So I think Casserly and Prather rely very heavily on that particular statute.
Well, but I think the issue was, could you bring them in? I don't think they addressed what happens if once brought in, and I think that one of them mentioned that if brought in, the defendant at that point could assert the statute of limitations.
And Your Honor, that is a viable reading, and in this particular case,
Let me just read the provision in Casserly. The new defendant only could take advantage of the fact that he was not made a party within a year, even if such a defense could be made by anyone. Doesn't that suggest that the newly brought in third party could assert defenses at that point?
yes, it does. It does sound as if that is a viable reading of that passage from the opinion.
Casserly, Well, then how is the Court of Appeal, other than the excess in the opinion that suggests that the statute of limitations is extinguished, the defense is extinguished, how is what the Court of Appeals done really an offense either to the Miller rule or the Casserly suggestion that the defense remains viable, not to the original defendant, but to the new third-party defendant?
So I think we have to look at this from the perspective of the Revocation of Paternity Act. The Revocation of Paternity Act specifically says in, I believe it's 722.1443, subsection 10, that common law actions to raise issues regarding paternity must be raised by June 12, 2014. So my reading of that says that the mother and the presumed father, the husband, would have to come to the court by June 12, 2014 to raise an issue regarding the child's paternity, that they are foreclosed from bringing the child's paternity, a question of the child's paternity up after June 12, 2014 via a claim that this husband is not the child's father.
You read the statute as precluding them from raising a defense?
Raising a claim.
Well, the claim has been made by the...
I understand.
The putative father,
I understand.
biological father, right?
What
so
I'm
that's
saying,
how the suit got started.
That's how the suit got started.
Are you saying once started, there are no defenses after a certain point?
No. I'm saying that because this statute opens this window of opportunity, the alleged father has until arguably June 12, 2013 to raise the issue. And I'm saying that the statute also says that the mother and the husband have a date with which they have to bring the claim as well, which is June 12, 2014.
What claim would they have brought? I'm just trying to follow your...
That's what I don't understand.
So
They're not contesting that the baby...
And that's my exact point.
Okay.
And by opening this back up, you're opening up, giving the husband, a new opportunity to raise a defense that he's foreclosed from raising as well. My client wants this to be done, final. And following the law as it is written and as it has been interpreted gives her that finality.
I still don't quite follow the argument that you're suggesting that if the legal father, I think that's the term, still the term, the husband,
right, is
brought in as a necessary party, he is foreclosed by the terms of the statute from raising a statute of limitations defense.
He is not foreclosed from raising a statute of limitations defense against the alleged father. I'm not arguing that. I'm not saying that.
If that is in fact raised on remand, doesn't that require the suit to be dismissed because he's a necessary party?
Absolutely.
But he's not required to raise that defense, is he?
That's my point. He's
Right.
not required.
No.
And then we reopen a case again.
Well, that's only if he chooses to waive his statute of limitations.
But from my client's perspective, the June 12, 2014 limitation in subsection 10 would prevent him from raising it as well.
But why? Because it's a defense, not a claim. I think that's what we're trying to get at. We're not quite sure why the husband couldn't raise a defense.
He can raise the defense. I'm not
Okay.
saying he can't. I do agree that he can raise the
But the
defense. But
mother
if he
can't.
doesn't raise the defense, it opens the case back up.
Yes.
And we're arguing over paternity, which in my client's opinion, that issue is closed because the June 12, 2014 date has lapsed.
I see. So maybe this is your argument. Your argument is that the putative father is being rewarded for failing to add the legal father in a timely fashion.
Absolutely.
If he had added the legal father in a timely fashion, the case either would proceed or it wouldn't have proceeded, but he didn't.
Right.
And now, 2 years after the fact, if the legal father doesn't assert the statute of limitations defense, the case will proceed. That is your argument.
Yes. And my client is then required to continue down this path.
Isn't it premature to address all this, though?
I don't think so, because I think the law is very clear. He's not allowed to bring in this party after the statute of limitations has run. My client would be prejudiced by allowing him into this case at this point.
Counselor, good morning. Happy New Year. I just have a question, though. Looking at this from kind of a large-scale implication, which is how we have to see it, help me to understand, though, like, as you're going through the discovery process, this information becomes available later. What would you do at that point? You know, the idea here is that you have a necessary party, and how would you handle a situation, you know, basically looking at this from more of a broader context, where ultimately you're going through the discovery process, you're not necessarily, maybe not in your case, but in other situations, you're not necessarily aware of the existence of this person. It becomes available to you throughout the process. What would happen at that point?
So I agree that if you did not know that that's a different set of facts altogether, and the Revocation of Paternity Act provides for a tolling of the statute of limitations. So I don't disagree that in the case where discovery reveals information that you could not have had prior to the filing, that should impact the statute. We don't have that set of facts here. In 2011, the plaintiff filed a paternity action under the Paternity Act, and the court dismissed the case, finding that Christopher Foster, the legal father, was indeed the legal father. He knew 2 years prior to the filing of this lawsuit that there was a legal father, and that person's name was Christopher Foster, and he chose not to add him to the complaint. I don't know why, but that's the facts we have today. And so I don't think this particular scenario warrants considerations of what he could have found out through discovery, because we know for a fact that he knew.
Why are we permitted to make actions, if the general principle is a party can be added but they can assert the defense, why should we make a determination now when the party hasn't been added and we don't know whether they'll raise or not raise the defense?
I would draw the court's attention to the relation-back doctrine that just precludes the addition of a party after the statute of limitations has run. I rely on that. That's why we shouldn't add them, because that gives certainty to plaintiffs and defendants that once that statute has run, their exposure is over. And in this particular case, I believe that is the appropriate course of action.
That's a good answer to the substantive question that underlies this case, but it really doesn't directly respond to Justice Young's question. Why do we need to resolve, or Justice Zara's question, why do we need to resolve it now? Why isn't it premature for us to be addressing that question at this juncture?
Well, I do believe that the way that the Court of Appeals opinion is written, it tends to lead one to believe that, in interpreting it, that the relation-back doctrine now allows you to add parties after the statute of limitations. That is not what the court opinions in Miller and the 30 cases that have come since. That has not been the court's opinion. So I think there needs to be clarity on that issue, that the relation-back doctrine.
But if that opinion is vacated.
I'm sorry?
If that opinion is vacated, if this court vacates that opinion.
Yes.
And says the legal father is indeed a necessary party, remand
right.
for any defenses that party may assert. Why can't the lower court address it then? I mean, you keep saying, well, you can't do it, but it's a defense that is waivable, and it's a defense that rests only in the legal father or the husband, no one else.
So, but that is not the way that the opinion was written.
The opinion, though, will be vacated.
No. You're talking about the Court of Appeals?
Correct.
Yeah.
The Court of Opinions opinion was not written that way.
But when we write one, that won't matter anymore.
Here's the argument.
So if
we say necessary party, remand, case done.
Absolutely.
No,
we go back to
eliminate all the statements in there about the relation back and all that for the.
We go back to the circuit court and argue the issue there.
Right. Okay. You're good with that?
Yes, I am.
Okay, perfect timing.
Thank you, Your Honor.
Thank you very much.
Good morning. May it please the court. My name is David Melton, appearing on behalf of plaintiff appellee Shae Kevin Graham. It's our position that the Court of Appeals properly decided the case, that under Cashley and Prather, the father or the husband is a necessary party. So being that he is a necessary party, then the relation back doctrine allows him to be, allows the matter to relate back to it being I guess, he can be served prior to the running of the statute of limitations. So it relates back to that. So therefore, he doesn't necessarily have this automatic defense that, well, the statute of limitations has run. It would relate back. So with the distinction with Cashley and Prather, the distinction between those cases and Miller is that Miller essentially indicates that under the court rule, MCR 2.118D, that relation back just relates to claims and not parties. But that particular court rule doesn't indicate that it can't relate back as it relates to parties. So it's silent as to that. And then going back to the statute itself, the Revocation of Paternity Act, the act is silent as to whether an alleged father, which is where my client is, has to actually name the presumed father, which is the husband. It's silent as to that issue. So if the court were to say that now my client, the statute is run, the presumed father has this defense, he would be precluded.
Counsel, I want to, if you could answer Sister Counsel's question, if you were aware of the existence of this individual and their importance to the matter at hand, why wasn't this individual added in a timely fashion?
Well, because this is a different act, it's new, the Revocation of Paternity Act, and I guess quite frankly, to more directly answer your question, there was a different attorney for that first action back in, I believe it was 2011.
So there was no transfer of information between counsel?
Well,
and no awareness that a legal father might be a necessary party?
Well, there was an awareness that this person existed.
Well, no, it's the legal awareness.
Yes.
That in a paternity action which the object is for the putative biological father to unseat the legal father's rights, doesn't it follow that the legal father is a necessary party if the act would actually sever the parental relationship? I mean, isn't that just kind of logical?
Right, and I understand that.
Well, that's a kind of a fatal flaw in the way the suit was brought, was it not?
Yes, yes, and I don't. But the thing is, if relying on the statute itself, just the plain language of the statute, it does provide for, if the mother brought this type of action, she has to name the presumed father. It's detailed in that regard, but it's silent as to.
Yeah, but we expect lawyers to understand simple things like you can't proceed on an action without all the necessary parties being in it. If the action is designed, as this one is, to affect the paternal rights of the legal father, it sounds to me like you have to say, got to have him in there.
Right.
You think it would have been perfectly appropriate for the action to proceed without the legal father involved and then have his rights severed?
Well, in this instance, he gets his opportunity to be made a part of this action.
No, not as the suit was brought, right?
Well, not as the suit was brought.
Okay, well, that's the problem here, isn't it?
Yes, it is.
Okay, so now the question is, now that he's been determined, and I think properly, so a necessary party, what is the effect of rejoining him in the suit? It seems to me these early cases are not relation-back cases at all. They only talk about it's permissible to add a necessary party. And the one case that I mentioned, the Casserly case, pretty much seems to acknowledge that once added, the necessary party can assert the defenses that they're entitled to assert.
And why would a different rule make sense? Why should it be the case that a party's ability to avail itself of a defense that's provided by statute, like a limitations defense, depends on the way in which the party is brought into the suit? Why would that make sense? That if you're brought in one way, you get to avail yourself of a statutorily provided defense, and if you're brought in a different way, nope, you're out of luck?
Well, it's simply allowing the plaintiff to amend his complaint.
No, the rule of Casserly is you get to amend your complaint. It does not say that you can amend your complaint without consequence. You're saying if I'm allowed to bring the father in, he's stripped of his right to say you didn't bring me in a timely fashion, and as to me, this cause of action is dead.
Why wouldn't everybody always play that game then? Bring somebody in a different way, so that they're precluded from using any statutorily defined.
Well, I read those cases to say that because this is a necessary party, then he must be added.
Yep.
And
with you
because
so
he
far.
must, and because he must be added, then plaintiff should be allowed to amend his complaint.
Sure.
We're with you so
You-
far.
You
And-
got it.
And
It's the
so,
next step, the relation back. Where do you find that?
well, I think that the relation back preserves
No,
essentially,
what's the source, what's the legal authority for the relation back of a later added party? The rule itself on relation back, as you've noted, and everybody notes, talks about claims and defenses. It doesn't talk about parties. And before Miller, there were cases that expressed the common understanding that relation back doctrine does not apply to the addition of new parties. There's a Coles decision out of the Court of Appeals in 2004, and that's an unremarkable proposition, right?
yes.
Until we get the Court of Appeals sort of engrafting into that notion that there are exceptions for the necessary parties. So that's the question I'm asking you. Where does that come from, that the exception to the general notion that parties don't relate back is accepted for necessary parties?
Well, just from the Court of Appeals holding, essentially that there's a due process interest in allowing the claim to relate back. Because
Who's due process?
well, due process of the presumed father, because this relates to parent-child
So
relationship.
the presumed father's interest predominate over the natural father's? The
Well-
natural father doesn't have any due process rights.
Well, in this, under this act, he has an interest as well. This act provides that he now can assert his rights to the child.
But that
So I
begs the
think,
question of whether it was all timely. You want to go to the rights under the act without ever addressing the question of whether it was timely.
well, but the act didn't require it. And I understand Justice's position that, well, the attorney should have known because this person was already out there. But if he is precluded, then the presumed father's due process rights are also affected, because then he would be barred from
He
bringing
can
the
waive the
claim.
defense.
The presumed
The presumed father, but the presumed father,
This is the person who brought
the
the
person who
act.
brought the claim.
Why is his due process
That's why I
right?
said the presumed father.
The presumed
Well-
father's the legal father.
Yeah.
Oh,
That's
I'm
the
sorry.
husband. Presumed father.
I'm sorry.
Right. The language has changed. The
How about
legal
husband and biological?
That's good.
Biological. So the biological, if he's cut off, he could be cut off now, and he has a due process interest
But
as
his-
well.
His due process interest should have been filed the suit on time.
Well-
You're not denied due process if you file the suit and name the necessary party, right?
Well, the suit itself was filed timely, but to name the presumed father, which was not in the statute, that's where things went
How
awry.
do you get around the Miller case?
Well, Miller, I think that there's a distinction that Miller does not address, well, a couple of things, necessary parties. And secondly, MCR 2.118D does not address relation back as it relates to necessary parties. So Miller is
Doesn't address any parties.
Right, that seems to me to work against you.
well, being that it doesn't address any parties, well, then we don't have a court rule or statute that says that.
The sentence in Miller that causes me concern as it relates to your position is this. Although an amendment generally relates back to the date of the original filing, if the new claim asserted arises out of the conduct, transaction, or occurrence set forth in the original pleading, then it cites to the court rule, the relation back doctrine does not extend to the addition of new parties. And this is a new party, isn't it?
It is a new party, but I think there's, under these circumstances, that this is a necessary party with a heightened level of interest, being this parent-child relationship. I believe that calls for allowing the claim to survive.
Can I ask, are you aware of any case, I understand there's some confusing cases out there,
Right.
Both from this court and the Court of Appeals, but is there any case you can identify in which this so-called necessary party exception was allowed to nullify a statute of limitations defense for a necessary party brought in after the statute of limitations period had expired?
I'm not aware of such. No.
With the possible exception, of course, of the instant case.
Yes. Yes.
The thing that troubles me is that in the series of Court of Appeals cases that seem to recognize this exception for necessary parties, they're all dicta. Those cases were all resolved on some other basis, but then went on to extemporize about, all the filigree that might happen if it was a necessary party. So
Right.
I'm unaware of a Michigan case that says squarely that a necessary party addition relates back to the filing of the original complaint.
Right. I would agree that I didn't find a case specifically on that point.
Okay.
My position is that there are other rationales for allowing this.
That would be helpful. Why would it be a good idea? Assuming, as I think we've established, there's no case that squarely holds that a necessary party's addition relates back. Why would it be a good policy, as a general matter, not just your suit, for a third party, a necessary third party, to be deprived, if the statute had been of limitations had expired as them, to be added back in without benefit of that defense?
Well, I think overall, it's better that no parties be deprived of their day in court.
Okay.
So to bring in this necessary party, that party has their day in court.
But the whole point of a statute of limitations is you don't have to suffer a day in court if the case, the claim has been brought too late.
Correct.
So having a day in court is not what you want if you're being sued.
Well, I think that it's a better policy to be more inclusive and to not bar someone's day in court.
Is there any argument to be made that there ought to be a distinction between a newly discoverable necessary party and an obviously not newly discoverable necessary party, as in this case?
Well, I think that even in this case, the husband was on notice. So it's not that he's totally caught off guard. There was a prior case.
But is it your position that he should have asked to be included in this?
Not that he should have asked. No, not saying that.
Okay.
But that he's not being caught off guard to the extent that if he were now brought into this matter, he can say that it's unfairly prejudicial to him because he did have some knowledge that this matter could arise.
That leads back to my original question, and I'd like you to kind of respond to sister counsel, which is, in this situation, this is not a case where the person was not aware of it, where they didn't know about this individual's existence. So how do I distinguish that? I mean, how do I distinguish that issue, that issue that I think is relevant here, which is the idea that they were aware of this person's existence, they knew of this person's existence. You yourself indicated that the individual in this situation, wasn't caught off guard. So how do you distinguish that in terms of the idea that, in a case where you have a situation where you're doing discovery and new information comes to light, so then, you're able to bring that person in, versus the case that we have here, where you yourself indicated that, this individual was not caught off guard, they knew that this was, proceeding, they knew that they were relevant to it, and they just weren't added. And again, they weren't added, and it's still unclear to me, your answer prior was because it was a different attorney. So how do I distinguish that? I mean, ultimately, the statute of limitations is not created to kind of prevent this kind of a situation. So help me to understand that distinguish. I know we have a time-sensitive issue, but that's what I'm struggling with. The idea between knowing about someone's existence and not including them versus not having any awareness of that person's existence and learning of it at a later date?
Well, yeah, those are two different situations, obviously, where,
Right.
But the thing is,
Why would we make a rule to favor your client?
well, I think that having prospective application, because in this situation, this is a new act, and being that this
Why
is.
would we ever have a rule that rewards somebody who is aware of a necessary party and doesn't add it?
Well, if that party was not aware that this was a necessary party, as opposed to just a
His lawyer
permissive.
was unaware of that.
Well, not that he was a necessary party, the
Can't
husband.
it be assumed that if litigation is going to result in the determination that an individual who believes himself to be a father will no longer be perceived as a father, that that individual should typically be viewed as a necessary party?
Yes, I would agree with that. Obviously, at this point, hindsight, it's
I don't see
pretty
how
clear.
foresight gets you into any other conclusion when we're talking literally about severing a parental relation, legally severing a parental relationship. That's not an inconsequential act.
Oh, certainly. And that's the thing. I believe that both parties have that heightened interest, the biological father as well as the husband.
So that's my
was the
question,
legal
though.
father.
At what point, help me to get this, at what point in your representation, well, I mean, I don't want to get too specific, and again, I want you to kind of answer the question delicately, but at what point was it determined that this was a necessary party,
Well,
and why?
it was determined that it was a necessary party only after the defendant in the lower court actually filed a motion for summary disposition. So prior to that, we went on, just naming the mother in the action. Now, in the lower court, the matter was brought up that, or it was determined that this was a necessary party. So even in the trial court, in the circuit court, there wasn't a determination at that point in time that the husband was a necessary party. It was only after the matter proceeded in the appellate court.
Okay, the time has elapsed. Are there any further questions?
Thank you.
Okay, thank you very much.
Thank you.
you.